Thank you, Charles Castagna, for joining us today to present on ethics in mediation. We really appreciate you doing this portion of our CLE for our attendees, and I look forward to learning a lot from you.
Good morning, Mercy, and thank you so much for having me. And good morning, everyone, whoever is watching and participating in this program. Again, my name is Charles Castagna. It's an honor and a privilege for me to present a quick overview, mainly of the standards of professional conduct for mediators. We're going to also touch briefly on Chapter 44 of the Florida statutes, mediation alternatives to judicial action, as well as Florida Rule of Civil Procedure 1.700, which is the Florida Rule of Court dealing with the mediation process. This is normally a 3 to 4 hour presentation that I allot to cover these topics. So we are going to be moving very quickly and really just highlighting what I think are the highlights. So I would encourage you, again, at your leisure to take a look at these rules and standards and statutes in your own time when you do have the time to do it. So let's get to it. I have bookmarked what we're going to be looking at today, and I am screen sharing here with you Chapter 44, Mediation Alternatives to Judicial Action. So let's start with the definition of mediation. Statutorily, mediation means a process whereby a neutral third person called a mediator acts to encourage and facilitate the resolution of a dispute between two or more parties. It is an informal and non-adversarial process with the objective of helping disputing parties reach a mutually acceptable and voluntary agreement. Decision-making in mediation rests with the parties. And the role of the mediator includes, but is not limited to, assisting the parties in identifying issues, fostering joint problem solving, and exploring settlement alternatives. And I wanted to take a little bit of time to go over that definition with you, because when we go through the statute a little bit further, we get to 44.107, which is mediator immunity, something near and dear to all of our hearts. Part of it does rest on making sure that in order to have the immunity, you are performing the statutory definition of what a mediator does. So again, it's important to know what that is. All right, let's look at immunity. That's the next thing I want to touch on. And as you can see here under 44.107 subsection 1, and we're going to focus here on mediators, not arbitrators, but also mediation trainees, as well as certified mediators, have the judicial immunity in the same manner and to the same extent as a judge. That's a wonderful grant of immunity. It's a very broad grant of immunity. But look at subsection 2. A person serving as a mediator in any non-court ordered mediation shall have immunity from liability arising from the performance of that person's duties while acting within the scope of the mediation function. And so, again, that's why I wanted to go over the definition with you in some detail, because it's important, I think, to distinguish between court-ordered and non-court ordered mediation insofar as the grant of immunity goes. And I would not for a minute suggest that, oh, if it's court-ordered, you've got a more a solid grant of immunity, and therefore you don't have to be as attentive to the mediator standards. I'm not saying that at all. It just appears from the language of the statute that there is a difference in terms of the immunity with court ordered versus non-court ordered. So again, look at that in more detail at your leisure. Let's see. I want to go next to the confidentiality and privilege portion of Chapter 44. A very important part of mediation is mediation confidentiality. It's a very broad scope of confidentiality, as you can see when you read this in more detail. But basically, the mediation process is confidential, except as required or permitted under Florida law. And it is important to understand the exceptions. We'll get to those here in just a couple of minutes. But it is, understand that it is a very broad grant of authority. And I would also like to mention now, at least in my opening remarks to the parties, I distinguish between general confidentiality, which is what this is referring to, and caucus confidentiality. And there is a difference in this sense that when you break into caucus, which, and again, some people think, well, you only do that if and when the mediation gets very contentious or the parties are very angry, or it's just getting to be a very uncomfortable situation, I would say those are certainly times to consider using caucus, but also sometimes it's just a good idea to meet privately with the parties, just to get a sense of where they're really coming from. Sometimes they're more comfortable speaking privately, so you don't need to wait until things either blow up or look like they're going to blow up before you have to adjourn into caucus. But when you do, it's very important that you let the parties understand, and there are two ways of doing this. That the caucus is confidential. Some mediators say everything is confidential unless you tell me it's not. And if you get the party's permission to do that, you can present it that way. I do it exactly the opposite. I tell the parties that nothing that you all share with me will I share with the other party unless you authorize me to do that, to share what we talk about in the private and confidential caucuses. The reason I do that is because that way I am absolutely 100% clear before I go from a caucus room into another caucus room, what I'm allowed to talk about and what I'm not allowed to talk about. It's too easy, in my view, to make a mistake, to assume something's confidential because they said, well, it's all confidential. And I can see so many pitfalls with that approach. However, a lot of mediators do that. There's nothing wrong with it. It's really a matter of personal preference. So I give you those two options in terms of how you want to handle caucus confidentiality. I also want to point out the definitions section here. And as you can see in subsection 2, mediation participant means a mediation party or a person who attends a mediation in person or by telephone, video conference, or other electronic means. And that's new language. The other electronic means has come into play in the last 2.5 years since we've been doing Zoom mediations as well as Zoom trainings like this one. But it is permissible now, either by order of the court or by agreement of the parties, for people to appear at mediation via Zoom and to have that count as an in-person attendance at the mediation. So that's important to know about as well. Let's see if we've got scope here. Again, just a very broad grant of confidentiality, except as otherwise provided. This section applies to any mediation under statute, court rule, agency rule, etc., conducted by express agreement of the parties, or in subsection C, facilitated by a certified mediator. So again, a very broad grant of immunity there, or I'm sorry, of confidentiality there. The exceptions I mentioned earlier, you can see here in section 405 of chapter 44, that again, all mediation communications are confidential except as provided here. And we scroll down and see there are, I believe it's 6 exceptions, 1, 2, 3, 4, 5, 6. So first of all, notwithstanding subsections 1 and 2, there's no confidentiality with regard to the agreement unless the parties agree otherwise. So understand that the agreement they may assume is confidential, it is not unless they make it so. But the 6 enumerated exceptions you can see here, if it's waived by the parties, if something during the mediation is willfully used, the communication is willfully used to plan a crime, commit or attempt to commit a crime, or conceal ongoing criminal activity or threaten violence, clearly not confidential. Number 3, anything requiring a mandatory report to chapters 39 or 415, and those are dealing with child abuse and vulnerable adult abuse. So those are clear statutory exceptions. Number 4, offered to report, prove, or disprove professional malpractice occurring during the mediation solely for the purpose of the professional malpractice proceeding. Number 5, offered for the limited purpose of establishing or refuting legally recognized grounds for voiding or reforming a settlement agreement reached during mediation. Or finally, offered to report, prove, or disprove professional misconduct, again, solely for the internal use of the body conducting the investigation of the conduct. So the point here is, and a lot of mediators do this, they take the shortcut, and I hear it discussed quite a bit anecdotally that it's confidential, period. There's not a period. There's not a full stop there. It's confidential, comma, except as required or permitted under Florida law. And you can see here what those exceptions are. And again, just so you're aware of it, civil remedies are provided here in 406 if confidentiality is breached. If a participant knowingly and willfully discloses a communication, bad things can happen if it's court ordered. and perhaps even, well, probably not in pre-suit so much, but well, you know what? I'm not sure about that. So hold that thought. But in any event, there are confidential remedies if someone does breach confidentiality that are financial in nature, but they are there nonetheless. All right, so let's now go to rules common to mediation and arbitration. And more specifically, we're going to focus here on mediation. Let's see. Okay. For some reason, the highlighting did not come out here. So I'm going to just refer to my own notes, and you can again at your leisure look at the rules at the rule here at your leisure. But the absent direction in the order of referral, and this is in 1.700A, a mediation or arbitration must be conducted in person unless the parties stipulate or the court on its own motion or motion by a party otherwise orders that the proceedings be conducted by communication technology. And that's the new language in the rule, or by a combination of communication technology and in-person participation. So now you can do it solely by communication technology if agreed or ordered by the court, or a hybrid where some people are there, other people are appearing. And usually I say Zoom. There are other programs available, obviously, that are utilized for this purpose. All right, so the next thing I want to touch on in the rule is the appearance of mediation. A party is deemed to appear at a mediation if the following persons are present. The party or a party representative having full authority to settle without further consultation, counsel of record, if any, or a representative of the insurance company, which you won't be having probably in the cases you all are handling, but a representative of the insurance carrier for any injured party who is not such outside carrier's outside counsel. So that's the definition of appearance at mediation. And again, full authority is required here by those who are participating in the mediation. All right, I think that's really all I want to touch on in the rule. Now, there is a provision, let's see, I do want to hit 1.730, completion of mediation. If there's no agreement reached as to any matter, then the mediator shall report the lack of agreement to the court. And again, this is in a court setting. There may or may not be a mediation report required in what you're doing. So just make sure you understand however the community law program is set up and established, whether there needs to be a report reflecting that no agreement was reached. If there was an agreement, then it is the mediator's obligation to see to it that the agreement is reduced to writing. The mediator, or memorialized appropriately is the term. The mediator does not have to be the scrivener, the one who writes the agreement, but it is the mediator's obligation to see to it that it gets done, whether it be by counsel, whether the mediator does it, or whether the parties do it, which I've never seen that done, and I've never asked parties to do that. I feel like that's my obligation if there is not counsel there to do it. All right, I think that's all I want to touch on in the rule. And now let me see if I was able to keep the highlighting in place for the standards of conduct. Yes, I did, thankfully. All right, so here we're looking at 10.200 of the standards of professional conduct for mediators. And again, I want to go through this in a little bit of detail just so you have a sense of it. These rules provide ethical standards of conduct for certified and court-appointed mediators. Court-appointed mediators are mediators selected by the parties or appointed by the court as the mediator in court-ordered mediations. These rules are intended to both guide mediators in the performance of their services and instill public confidence in the mediation process. The public's use, understanding, and satisfaction with mediation can only be achieved if mediators embrace the highest ethical principles. Whether the parties involved in a mediation choose to resolve their dispute is secondary in importance to whether the mediator conducts the mediation in accordance with these ethical standards. And I want to go over that last sentence again. It's a very important one, and it's one that I can tell you this, in the real world, whether it's court ordered or not court ordered, whether it's pre-suit or private, whether it's family or the program that the community law is involved in, that there either is a natural temptation on the part of the mediator, or the parties and or counsel may really be leaning on the mediator, urging the mediator, pushing the mediator to do whatever it takes to get the matter settled. And again, I'm the first to tell you, you want to work hard as a mediator. It's very challenging work. You don't want to give up easily at the first sign of someone not agreeing. You want to work hard, but you have to understand that in terms of the people who look over our shoulders and who conduct the disciplinary process, which is another whole presentation we're not going to get into today, but the standards do have a disciplinary mechanism that those committees that conduct those processes are looking at it, saying, we the committees think that it's important to settle, but it's secondary in importance to whether the mediator does what he or she is supposed to do under these standards. So they are important. I think there's a lot of leeway to be an effective mediator, to be a proactive mediator, to be very engaged in the process, which again, I think is very important, but without crossing the line and twisting someone's arm or pressuring them or somehow trying to make them do something they don't want to do, or stepping out of line and giving an opinion about how you think the case should be resolved or how you think a judge might rule on it, or if it's in court, how the judge in this case would rule on it. Those are all prohibited things, and we'll get to more in more detail on those here shortly. Again, the definition of mediation, a process whereby a neutral and impartial third person, and this is very important. You need to be neutral, you need to be impartial, and you need to make any disclosures on the front end that might cause you not to be neutral and impartial. And if you feel that you can't be neutral and impartial, then you really should, well, not really, you should not mediate that case. And that's a very clear thing. There may be some relationship or whatever it is that would cause you to take sides or to want to favor one party over the other. You can't do it. That's a conflict of interest. There's another rule on that as well. And so you don't want to be in that position as the mediator. So again, neutral and impartial, you're there to facilitate, not to decide it, not to prescribe what the outcome should be. It's an informal and non-adversarial process, again, intended to help the disputing parties reach a mutually acceptable agreement. The mediator's role here is outlined in 10.220. The role of the mediator is to reduce obstacles to communication, assist in the identification of issues and exploration of alternatives, and otherwise facilitate voluntary agreements resolving the dispute. However, ultimate decision-making authority rests with the parties. They're the ones that decide, and you have to understand and honor and respect that aspect of it. As tempting as it may be to do otherwise, that's our ethical obligation. And the concepts here are self-determination, needs and interests of the parties, fairness, procedural flexibility, confidentiality, and full disclosure. So now looking down here, and this I think kind of reiterates what we just talked about in terms of what responsibility the mediator has to the parties, and that is to, again, provide a forum for consensual dispute resolution. And here's the distinction. Somebody may say, well, I had to be here. The program required that I do this before we could go forward. The point is, whether you are ordered to mediation or not, you don't have to settle the case. That's entirely up to you. And so it is consensual in that sense. Even when it's court ordered, the parties don't have to settle. And so that's the point of it being a consensual process. And a mediator is also responsible for maintaining an appropriate demeanor. And I think we'll come to it here in a little bit, but there's a rule that says, you would think there wouldn't have to be a rule, but there is a rule that says that a mediator shall be patient, dignified, and courteous. So I guess there have been situations where mediators have not done those things, so they had to come up with putting it in black and white here. Self-determination is a really critical part of the standards 10.310 goes into some detail on that. Clearly, again, coercion is prohibited by the rule, and so you can't make someone unwillingly participate or certainly unwillingly sign or enter into an agreement. And decision making, again, is up to the parties, and it's not your job. Not only is it not your job, you cannot make substantive decisions for the parties. That would be prohibited. As is misrepresentation. You can see here in subsection C, you shall not knowingly or intentionally misrepresent any material fact. And so that's pretty much all I want to touch on in self-determination. Let's see, I'm kind of highlighting things here. Impartiality, I think we talked about a little bit earlier. A mediator shall maintain impartiality throughout the process. And this is a good definition of it: freedom from bias, favoritism in word, action, or appearance, and includes a commitment to assist all parties as opposed to any one individual. And I'm going to go ahead and get through the second section as well here. Withdrawal for partiality. A mediator shall withdraw if the mediator is no longer impartial. Now, I've never had this happen, but just a very brief illustration where I have seen it happen. I had a mentee, once sitting in to get her certification required observation in, and it happened to be a family case, and the parties were, it was very early in the process. People were going around the table introducing themselves, the wife's lawyer, the wife, the husband's lawyer, and the husband says, "Good morning, my name is John Smith." And the person who was there observing with me said, "We need to take a break." And her face was red. She was visibly upset. And so I said, "Well, we'll take a short break here. We'll be right back." And I went out in the hall with her. She says that, I won't use the description that she used, "That man reminds me so much of my former husband. I can't sit in the same room with him." Who would have known? Who thought? But in any event, she could no longer be impartial. She left. When I came back, I just told him that she had gotten ill, which was true in a manner of speaking, and had to leave, which she did, and decided she wasn't going to become a family mediator because she didn't know when that was going to happen again. I don't know why it didn't occur to her that it might, but in any event, things can happen. Someone might make a comment, might insult you or insult the other party, or use language that you find offensive, or anything that could cause you to no longer be impartial. If that happens, you need to call it what it is. I mean, you don't need to say that to the other party, but you need to recognize that it's happened and remove yourself, withdraw from the mediation. Again, I've never had that happen. I think it would be kind of an awkward thing, but again, it's pretty clear in the rule what you have to do if something like that happens. So that's impartiality, and it's important to keep in mind. And there are a lot of committee notes here. We're not even getting into those, but take a look at them. They give some good elaboration on these standards. Conflicts of interest, we're not going to get into too much here with that. You can read these, but basically, if there's a clear or undisclosed conflict, if one of the parties is a close relative, or a former business partner, or if you're a lawyer and you happen to represent them in a case before, these are the kinds of things that would be a clear conflict. And obviously you should have known that before and made the disclosure in time. And here they tell you in subsection B that the burden of disclosure rests on the mediator, and it should be made as soon as practicable. The disclosure should be made as soon as practical after the mediator is aware of the interest or relationship giving rise to the potential conflict. And that way the parties have the opportunity to engage another mediator. So that's the conflict of interest section. Here's the patient, dignified, and courteous part I told you about, 10.350. Confidentiality, we talked about as well. Here you can see in subsection B that information obtained during caucus may not be revealed without the consent of the disclosing parties. And there has been, I think, MEAC opinions that have elaborated on that and have since broadened that to say that a mediator, with the agreement of the parties, can say, can create a broader rule that allows them to have more leeway in terms of making determinations about what to keep confidential and what not. Again, I don't want that responsibility. I think it's much cleaner and much safer ethically, and in terms of preserving confidentiality, to say, okay, this is what we've talked about. You've authorized me to talk about A, B, and C. That's what I'm going to talk about in the other room. Are we good? It's real easy for them to say yes or no. And usually they say yes. And if they say no, it's a good thing that I asked. So that's that. Advice, opinions, or information is another important rule. You're not supposed to give legal advice, certainly if you're not a lawyer, especially if you're not a lawyer, but even if you are a lawyer, you shouldn't be giving legal advice in the mediation. You are required, if you believe a party doesn't understand how an agreement will affect legal rights, then you tell them they need to get a lawyer, and they have the opportunity to do that. So that's provided here in the rule as well. And let's see, we've got a couple of minutes left. The last thing I think I want to get to here is the, in terms of the process and the conduct of the mediation, 10.420, orientation session upon commencement, a mediator shall, you have to make an opening statement. Even if the parties say, we've been through this before, we don't want to hear it again, with all due respect, please indulge me, it won't take long. And you go through it. And here it tells you basically what to say. Mediation is consensual. Mediator is an impartial facilitator. Communications are confidential, except where required by law. You know, you say a little bit more than that. You go into a little more detail, but that's the gist of what you're supposed to cover in your opening statement. One thing I do tell them, by the way, we talked about this before with the impartiality, is I tell them it's my role and responsibility to be neutral and impartial. And if you think that I'm somehow taking sides, helping one party over the other, doing anything at all that makes you uncomfortable with the process or how I'm conducting it, please let me know. And the reason that I do that is I want to know now today, because I can do something about it, rather than after the fact. If they have a concern and they think that they maybe need to file an ethical, a grievance or whatever, I'd rather talk about it now, deal with it now, and tell them, look, I'm supposed to not take sides and to help both of you, not one or the other. If you have any concerns at all, let me know, we'll address it and make sure there's not a problem. And knock on wood, that's always worked. I can't even remember the last time someone has brought it up, but at least I'm giving them the opportunity to do that. Adjournment or termination, and this is probably the last thing we're going to have time to cover here. And it's very important. There are requirements here. A mediator shall, that's the prefatory language there in subsection B. Adjourn upon agreement of the parties, adjourn or terminate any mediation which, if continued, would result in unreasonable emotional or monetary cost to the parties. If someone's really getting upset, you can try caucusing. That may or may not deal with whatever the underlying issue is. If it gets to the point, and again, this is a judgment call on the part of the mediator. If you believe that there is emotional consternation to the point that people can't really function effectively, you need to adjourn or terminate. You can continue if everyone agrees to a continuance, or you can end it and just say there was no agreement reached, and that would be the outcome of the mediation. Number 3, adjourn or terminate the mediation if the mediator believes, and again, this is a subjective judgment call on the part of the mediator. If the mediator believes the case is unsuitable for mediation, or any party is unable or unwilling to participate meaningfully in the process. So again, they have to be there, maybe if it's court ordered, or if there's a contract requirement, or whatever the requirement is that they're there, they don't have to stay. And that's the long and the short of it on that. Number 4, terminate a mediation entailing fraud, duress, the absence of bargaining ability, or unconscionability. And again, hopefully these things don't come up. But again, if they do, then you shall terminate the mediation. And finally, terminate any mediation if the physical safety of any person is endangered by the continuation of the mediation. And again, with Zoom, that's much less of a problem, because at least people typically aren't in the same place, although they could, I guess, be on one screen and you're on another, but even still, if you see something happening that is problematic, obviously you're going to A, terminate, and B, you may have to call, hang up, terminate the mediation and dial 911 if it's that kind of a situation. But again, hopefully that doesn't happen. I've never had that happen. But again, your obligation is to terminate if physical safety is an issue. And then finally, closure, and this will be our last point here today. The mediator shall cause the terms of any agreement to be memorialized appropriately and discuss with parties and counsel how that's going to happen. And so again, and the best practice is to write it there. If you're doing it on Zoom, you can write it, you can do it in a Word document. There are programs, DocuSign and Adobe. I'm not sure what the program is with Adobe, but there are programs out there where you can actually have an agreement signed electronically, and that's an option. Or I do it the old school way, do it in a Word document, email it to the parties or counsel, and they sign it. And it takes a little bit longer, but it works just fine. Excuse me. So again, you have an obligation to do something or to see to it that it's going to get done. If the lawyers say they want to do it, or the parties, that's okay, but you just have to follow up and make sure that it gets done. So I think that's all we're going to get to today. And I apologize if I've been talking too fast. I hope it's been understandable, and that you all are at least have a sense of what these standards are all about. And so again, I want to thank the Community Law Program and Kimberly Rogers and Mercy Roberg for having me present here today. And I hope this has been helpful for you. Thank you so much.
Thank you, Charles. We appreciate your time and going through this with us and our audience. So thank you for an excellent presentation.
Thank you. My pleasure.